the concept of civil union is playing out now today as a factor in the marriage equality movement. I mean, we've seen some transitions from civil union to marriage. We've seen some new civil union-like legislation passed, I guess Nevada, most recently, Washington, state of Washington, calling it something different, but nonetheless essentially the same thing. How do you both think that this is playing a part? Where is it as a part of this goal of marriage equality across the country?
One thing I'll say is it was interesting when you described different names but essentially the same thing, because I think that one of the real lessons that I've at least come to understand over the past decade is how much words matter, and how much what we call something isn't just sort of a throwaway aside. And I actually think that there is a difference between even the California Domestic Partnership Statute and civil unions in Vermont, precisely because of what we call them. And what I mean by that is domestic partnership statutes don't pretend to be equal to marriage. Nobody understands them that way. They're not represented as such. I think one of the traps that the civil union law created was we spent a long time working with leadership in the legislature to try to come up with a name that we felt was sufficiently dignified and respectful, and at some level was more easily confused as equal. And I think in retrospect that was a mistake. And so the advice that I've been giving to folks around the country is, if you're going to go sort of through an incremental process, don't call it civil union, because that actually makes it, it creates more problems than it helps. And it's great to get sort of tangible legal benefits, but there's something about that term that I think is dangerous. So that's just one thought I wanted to add.
Am I right in remembering that there was a little glitch in Vermont about whether you could solemnize a civil union as opposed to not, and that's one thing that would make it different?
Yeah, there were a couple of very slight statutory differences between a civil union and marriage, and they really had to do with individual idiosyncrasies of individual legislators, because that's how close the vote was to pass a civil union law. So, there was a legislator who didn't want to solemnize civil unions because that seemed too close to being equal to marriage. So you celebrate a civil union, which is also a term that's used in case law about marriage, but it's not in the statute. There's another legislator who didn't want to have divorce for civil unions, and so it's called a dissolution. So there were these little tiny things, and I mean that happens. That's one of the differences between courts and legislatures, is you find yourself creating laws with these little idiosyncrasies because Joe Schmo from Plymouth needs to have that. There was actually one day, it was maybe even 2 days, when it was going to be civil accord. And it was going to be civil accord because the Republicans from Manchester and the House of Manchester, Vermont, and the House Judiciary Committee read it somewhere that's what they called it in France, and she thought that sounded really cool, and we needed her vote. And so it was almost going to be civil accord because that's what it was going to take to get her vote. Thankfully, we didn't go that route.
Sounds like a car. Yeah, I think really Beth said it very well, but it did.
Because I guess we talked a little bit about the notion of this. We've now seen California and Connecticut move from, in court decisions, from either a civil union or a domestic partnership to marriage, that arguably it puts a pressure on legislators not to go there because they see it just as an automatic next step. They're just setting marriage up, and
I mean, I think
depending on the court.
That was the huge breakthrough of Maine, though, this year. And Maine has been huge for so many reasons, and remains huge because it's our first opportunity to win the ballot box, and I think we can do it with Marry Gary's great leadership and all the folks up there in Maine who are doing so much great work. But to go straight to marriage legislatively without sort of having to go through this intermediate step, I think to me that signaled that, okay, you know, we sort of taken the training wheels off, this experiment has run its course, it served a purpose, but I don't think we're necessarily gonna have to sort of do it as a two-step process anymore. And I really thank Maine for that, because I think somebody had to break that barrier, otherwise we were gonna see two steps everywhere.
And I think that's a fair point, although I'll just point out about Maine, and like in any state, you can't go from A to Z, so Maine, you know, has domestic partnership registry from 2004 that gives you 6 rights, and a few other, you know, small things that have happened over the years, and there's certainly been some activity in the courts in terms of second parent adoption and de facto parenting, and from the executive branch in terms of making domestic partnership benefits available to state employees that started in the university system in the 90s, but then moved across the board. So what you have is all 3 branches having been engaged at some level in grappling with families of gay and lesbian people and the problems and the gaps, so that it's true we didn't go to civil unions or an already registered domestic partnership system, but it was all in the mix. And because they've been grappling with these things and these issues for so long now, we were able to make the case about marriage. And really, as I think everyone in Massachusetts knows, with no disrespect at all to Vermont, but what we had to do, of course, is fight off civil unions, because it's where everybody wants to go. On the radio today, it's where everybody wanted to go. Our opponents were like, why can't we just do civil unions? It's like, well, because you opposed domestic partnership in 2004 as well. This is really kind of a hollow conversation. So anyway, it's where people want to go, and it's so important for all of us to be clear, I think, at this juncture, that we can't have separate systems for minority groups. We've learned that lesson already.